Good evening, everyone, and welcome to the launch event for Volume 45, Issue 2 of the University of New South Wales Law Journal. On behalf of the Journal, I would like to begin tonight's proceedings by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which we gather here this evening. We pay our respects to their elders past, present, and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples joining us for this occasion. My name is Darius Dadgosta, and I am the Executive Editor of the University of New South Wales Law Journal. It is a privilege to welcome everyone here tonight at the Sydney office of Herbert Smith Freehills to the launch event for Volume 45, Issue 2 of the UNSW Law Journal, the journal's second in-person launch event this year. The UNSW Law Journal is very proud of its long-standing relationship with Premier Sponsor Herbert Smith Freehills, which since 1982 has been integral to the journal's development and present status as one of Australia's leading academic law reviews. The journal would not be the esteemed publication that it is today without the over 40 years of continuing support from Herbert Smith Freehills. I would like to thank in particular Ms. Elizabeth Pittaway-Burnell and Antonia Xu for their assistance in helping organise tonight's event, and Mr. Luke Hastings, Dispute Resolution Partner and Sponsor Partner of the Australian Ability Network at Herbert Smith Freehills, who will be speaking on behalf of the firm shortly. I would also like to thank the journal's other premier sponsors, Allens, Cause Chambers Westgar, and King & Wood Mallisons for their invaluable support. Issue 45-2 of the UNSW Law Journal is a general issue containing 12 articles that explore an array of legal topics. The theme of tonight's launch, Equity in the Workplace, was inspired by two articles featured in Issue 45-2. One by Ms. Natalie Sheard, which examines the extent to which Australian anti-discrimination laws are able to regulate the use of discriminatory algorithmic hiring systems by employers, and another by Dr. Angelo Capuano, which analyses whether Australian labour and anti-discrimination laws are equipped to deal with the inequalities that arise from the post-pandemic world of hybrid workplace design. The UNSW Law Journal recognises the importance of diversity and equity in the legal academy and profession, specifically in facilitating the robust exchange of ideas and critical thought necessary to promote a more just and equitable legal system and society. Accordingly, the UNSW Law Journal is committed to supporting diversity and equity within the editorial board and the legal academy more broadly, particularly by encouraging diverse legal scholarship in terms of authorship, subject matter, and theoretical approach. This commitment is enshrined in the UNSW Law Journal's recently launched diversity statement, which is now available on the journal's website. I would like to thank Dr. Ben Gauntlett, Disability Discrimination Commissioner at the Australian Human Rights Commission, for joining us this evening to deliver tonight's highly anticipated keynote address on equity in the workplace. I would also like to thank the authors of Issue 45-2, some of whom are here this evening, for entrusting the UNSW Law Journal with their insightful scholarly works. Congratulations are also in order for Kriti Shori, the editor of Issue 45-2, for working so tirelessly in coordinating the peer review and editing of the articles in this issue. Seeing an entire issue through to publication is a remarkable achievement, and the editorial board is very proud of how Kriti has done so with such dedication, conscientiousness, and commitment to diversity. I would also like to take this opportunity to thank the rest of the editorial board for their many hours of meticulous editing, and welcome to the journal's executive committee, Kriti's successor, Hayden Clift, who I'm sure will also be a great issue editor. Last but not least, I would like to thank the UNSW Faculty of Law and Justice, particularly the faculty's dean, Professor Andrew Lynch, who will be delivering a vote of thanks later this evening, and faculty advisors Professors Gary Edmond and Rosalind Dixon for their steadfast support of the journal and editorial board. It is now my pleasure to invite Antonia Xu, solicitor at Herbert Smith Freehills and former executive editor of the UNSW Law Journal, to speak. Thank you, Antonia.
Thanks so much, Darius, and hello everyone. I'd also like to acknowledge the traditional owners of the land on which we meet today, the Gadigal people of the Eora Nation, and pay my respects to all Aboriginal elders past, present and emerging. I extend that respect to any Aboriginal and Torres Strait Islander peoples here today. It is mine and Luke's privilege tonight to welcome you all to the firm. My name is Antonia, and as some of you might know, I was a member of the editorial board during my time at university and was its executive editor during 2020. I'm now working as a junior solicitor at Herbert Smith Freehills, and in that sense I'm particularly thrilled to have been asked to be involved in this event. I'm really proud to say that Herbert Smith Freehills is, as Darius has mentioned, one of the longest running sponsors of the UNSW Law Journal. It's been a sponsor since 1982, and that's 40 years of sponsorship. I know from my time on the executive committee that academia can sometimes be a grueling and slow-moving beast, so a huge congratulations is due to the editorial board and all the fantastic authors whose work we're celebrating at this launch tonight. I'd like to make a particular mention also to Angelo Capitano and Natalie Sherd, whose works have lent their contemporary and incisive ideas to tonight's launch topic, equity in the workplace. Thanks is also due to Dr. Gauntlett for your time in delivering the keynote tonight. We're excited to hear your reflections on these important topics, and as you are an alum of the firm as well, it is my privilege not to extend a welcome, but also a welcome back. Equity in the workplace, tonight's launch topic, is of course a live and pertinent consideration and issue for our workplace as well. One of the partner sponsors of our Ability Network, as Darius has also introduced, Luke Hastings, is also with us tonight and will shortly bring together some of our reflections and initiatives on these important and difficult issues. I'll now pass on to Luke.
Thank you very much, Antonia. I'd like to also acknowledge the traditional owners of the land on which we meet. We're incredibly honoured to support the scholarship in this issue of the New South Wales Law Journal and to be a part of the conversations that it generates. Just looking at this tome in this modern digital world and seeing something this thick printed handed around is impressive to say the least. I'd also like to endorse Antonia's recognition of all the authors and the editorial board for your thoughtful and impressive contributions on such a wide range of contemporary issues, from criminal sentencing, involuntary assisted suicide and so-called mercy killing, to the duties of directors of companies in the not-for-profit and charitable sectors and everywhere in between. And many of these topics are particularly timely given the ongoing Royal Commission into violence, abuse, neglect and exploitation of people with disability. As Antonia mentioned, I'm a partner sponsor of the HSF Ability Network. This is one of 5 networks of the firm which aims to enhance diversity and inclusion. The goal of the Ability Network is to create awareness and foster an inclusive workplace that values and supports people with disabilities and those that care for people with disabilities. It has influenced HSF's policies on reasonable adjustments and accessibility. Our most recent diversity and inclusion audit showed that 10% of our staff identify as having a disability. That is almost certainly underreported. Dr. Angelo Capuano's article on post-pandemic workplace design and the plight of employees with invisible disabilities resonated with me. Last May, we hosted a roundtable event entitled The Invisibility of Disability, with a wide spectrum of distinguished guests, including tonight's speaker, Dr. Gauntlett. The issues raised have only continued to proliferate as the pandemic continues its disruptive impact. Natalie Sheard's article, and it's wonderful, Natalie, to have you here this evening, on employment discrimination arising from algorithmic hiring systems and the ability for Australian anti-discrimination laws to regulate the use of such systems also resonates. The HSF Ability Network has a recruitment work stream focused on improving disability inclusion and a culture where people feel comfortable disclosing their disabilities. In our 2021-22 summer clerkship recruitment process, we used LinkedIn and other avenues to proactively welcome applications from people with a disability. This led to a substantial increase in the number of students disclosing a disability to us during the recruitment process, 4.5% of the total applicants. Now, for context, that is 93 candidates versus 80 candidates in the 3 combined years of applications. Of those candidates, we interviewed 11 and 5 candidates with a disability were hired. I share this example just to show how a relatively easy intervention in the recruitment process, in this case tweaking our recruitment communications to specifically welcome applications from people with a disability, can result in quite substantial improvement. It's now my privilege to welcome Dr Ben Gauntlett, as you've heard, Disability Discrimination Commissioner at the Australian Human Rights Commission, and as Antonia notes, an alumnus of the firm, to address us and give the keynote address. But before I do that, can I invite the editor of this issue, Akriti Sharee, to speak.
Hello, everybody. Thank you so much, Darius, Antonia, and Luke, for your kind comments and introduction. I also acknowledge the traditional owners and custodians of the lands on which we meet today, the Gadigal people of the Eora Nation. I pay my respects to their elders, past, present, and emerging, and acknowledge any Aboriginal people present here today. This land always was and always will be Aboriginal land. I am incredibly proud to launch issue 45.2 of the University of New South Wales Law Journal, and I'm so grateful to be able to celebrate in person together with all of you. This general issue, as Darius noted, contains 12 insightful articles that continue our track record of publishing quality scholarship that canvasses a range of legal issues that are as broad as our readership. I hope that everyone who takes home a copy today for some light bedtime reading, and everyone who reads articles from this issue long into the future enjoys learning something new. Thank you to the 15 authors of this issue, some of whom who have been published in the journal before, and thank you to everyone who's attending. We are so honoured to have been entrusted with editing and publishing your work, without which the journal would not exist. Thank you for your patience throughout the very long publication process and for so graciously considering all of our suggestions. Thank you. The theme that I have chosen for today, equity in the workplace, as has been said before, is inspired primarily by 2 articles of this issue, both of which discuss new and emerging vectors of discrimination in employment. So Natalie Sheard's article, which demonstrates biases inherent in algorithmic hiring systems, is, I think, particularly relevant to many of the students here today. We know that targeted advertisements, CV passing systems, video interview assessment systems, they all promise to make hiring systems more efficient, to remove human subjectivity, but as the article shows, they may entrench and perpetuate historical discrimination along lines of race, language, gender, disability, social class, and more, all by virtue of the way that they are designed. And current Australian discrimination laws are not enough, so lawmakers are finding themselves playing catch-up to address the negative effects of these new technologies. The second article is Dr. Capuano's article, which discusses the impacts of workplace design on those with so-called invisible disabilities, such as chronic illness, sensory impairments, mental illness, and neurodivergencies. These disabilities and neurodivergencies may not be obvious to others and are therefore often subject to significant ableism. And we all know that COVID-19 has forced us to reimagine the way that we work, and all signs point to hybrid work arrangements continuing long into the future. And so this article, which is so timely in light of the Disability Royal Commission, shows that the shift in workplace design is disproportionately impacting people with these disabilities in very specific ways. And again, current Australian discrimination laws must be updated to deal effectively with these emerging inequalities. But it's not just the law, we all have personal responsibility as well. The other articles in this issue are equally timely. In the wake of Prime Minister Anthony Albanese's commitment to the Uluru Statement from the Heart, we have an article from Daniel Lavery, which re-examines the current orthodox theory of Australian territorial sovereignty, and it shows that it is still based on false historical narratives and that our politics and jurisprudence continues to inadequately account for the inherent and continuing sovereignty of Indigenous Australians. Recently, voluntary assisted dying was legalised in every Australian state, and Katrine Delvilla, Lindy Wilmot and Ben White continue their work in this area with their article, which examines all of the publicly available sentencing remarks in criminal assisted suicide cases and presents avenues for law reforms to improve consistency in that area. Tamara Walsh considers the applicability of the Victorian Human Rights Charter to social housing evictions. Mina Cousins argues that our migration and terrorism laws are incompatible with the United Nations Convention on the Rights of the Child. Andrew Terry clarifies the ambiguous legal position of industry codes of conduct, and Gianne Neldecoca examines whether volunteer charity directors should be held to the same standards as their paid counterparts. We have an article from Lisa Spagnolo and Sharon Roderick, which calls for a streamlining of approaches to indefeasibility in the area of land law, and Ben Matthews undertakes the first comprehensive analysis of the various laws and obligations that apply to people who undertake research about child maltreatment in Australia. And finally, in light of the controversial merging of the federal circuit and family courts late last year, Brian Opskin studies the ways that our government has attempted to balance cost effectiveness, efficiency and justice in our dispute resolution systems, and he cautions against losing sight of the primary values of our legal system in our search for affordability. So once again, I'm so proud to have spearheaded the publication of authorship that is so incisive in its analysis and always forward-looking in its approach. General issues of the University of New South Wales Law Journal don't begin with a theme, rather one is conceived over the course of the year. My thoughts on the subject, equality in the workplace, have been shaped by my experiences working on this issue. I've spent so much time working in our little office in the law building, and it truly has been my workplace this year. In fact, I think I've spent more time working on this issue than I have on university and my actual job combined. And I've learnt so much doing this job this year. If I'm being honest, the imposter syndrome almost stopped me from going for this role, but seeing an executive committee heading this institution that so clearly reflected my identity in more ways than one, empowered me to take on a leadership role. And their support and their belief in me has helped me be successful in this role because it gave me the space to be proud of and confident in what I can contribute to this organisation. Being part of this organisation in any capacity requires an immense amount of passion, curiosity, diligence and grueling effort, and I am so proud that we produce such quality work and that we're held in such high esteem by the Australian legal community. But being able to participate in this process does reflect a level of privilege, as everyone that has read my editorial will know. I know that many students who would be excellent editors and no doubt better issue editors than I are barred from participating in this process because of a multitude of factors: carrying responsibilities, a need to prioritise paid work over voluntary commitments like this one, and so much more. I'm very proud that during my tenure, the 2021 and 2022 executive committees both reaffirmed the Journal's commitment to promoting diversity on the editorial board through our internal recruitment processes and an active focus on the recruitment of Indigenous students, which is all now reflected in our diversity statement. We have worked to be flexible and accommodate the various needs of our diverse board members, without whom the Journal just could not function. And we have worked to foster the Journal community's supportive culture. The Journal is just one institution within the broader institution that is academia. And it's no secret that although the state of affairs has greatly improved over time, the academic workplace is not quite yet equitable. And the 2021 and 2022 executive committees have again been dedicated to better understanding the role that the journal plays in upholding systemic barriers to publication in academia and work towards redressing them. But more can always be done, and we must continue to be consistent and dynamic in our efforts to improve diversity and equity going forward. So, to help me decide what I wanted to say tonight, I looked back at what issue editors have said in the past, and Chan, issue editor of issue 43.4, said in his speech that it takes a village to create an issue. And I want to extend that metaphor by saying that this publication has relied on a village of people, and that all of those villages have in turn required a city's worth of supporters. So I've said thank you to the authors, but thank you also to every academic and legal practitioner who has ever reviewed an article for us. Your expertise is always instrumental in ensuring that the journal is able to continue publishing such excellent articles. Thank you to my peers on the editorial board, for whom I have the deepest appreciation. The care and attention that you have put into every edit is at the heart of what makes this journal a great one, and your friendship is what makes being part of the journal so fulfilling. And thank you to the friends and families of all the board who support them while they hunker down for a couple of weeks, a few times every year, to fact check every proposition that's made in these 500 or so pages. Thank you to the executive committees that I have worked with. You're all so intelligent, so resilient, so capable and kind, and I hope that this speech isn't the first time that you're hearing that from me. Executive editors Tina and Darius, thank you so much for your calm and measured leadership, for patiently answering even the silliest of questions that I have for you. To our forum editors, Arani and Izzy, and digital editors, Caitlin and Callum, your efforts are so invaluable. You've always gone above and beyond. Thank you. To the issue editors that preceded me, Lillian, Alicia, and Kari, thank you for guiding and believing in me. Particularly to Kari, without whose nagging I probably wouldn't have applied for this position. And to the issue editors that follow me, Kat, Georgia, Enrico, your support has really kept me steady this year. And this really, truly has been a team effort. If I have one gripe with you all, it's that Georgia didn't follow through on her promise to do an interpretive dance for us all at my launch. So, if you see Georgia after the formal proceedings are over, maybe she can demonstrate for you. And congratulations to Hayden, my recently elected successor, the editor of issue 46.2. I can already see that your issue on the theme of law and the life sciences will be a very impressive one. And to those that support the executive committee behind the scenes, I am so indebted to our faculty advisors, Ros Dixon and Gary Edmond, who have such an uncanny ability to turn mountains back into molehills. And thank you to Andrew Lynch, the Dean of the University of New South Wales' Faculty of Law and Justice. You are very loved by the student body. I know that because I saw a cutout of your head pasted on the door of the Student Law Society's office, and it's got little hearts stuck all around it. And it is because you always show up like this in support of us and the things that we do. So thank you. Thank you to our typesetter, Kerry Cook, and to the designer of our cover, John Hewitt. Thank you to the librarians for processing so many interlibrary loans this issue. Our work would really be impossible without them. And as always, the journal is so grateful for the continued support of our premier sponsors, Herbert Smith Freehills, Allens, and King & Wood Mallisons, who this year have been joined by Cause Chambers Westgarth. Thank you in particular to Herbert Smith Freehills for hosting this launch, and to Elizabeth for helping coordinate the event. And on a more personal level, to my city of supporters, thank you to my parents, Geeta and Samir. You've always believed in me, and you've raised me to believe in myself. So thank you, I owe it all to you. Thank you to my sister, Anahita, who didn't really understand what I did at the Law Journal until about 3 weeks ago, but she really cheered me on anyway. And she tells me that she's offended that I didn't thank my dog in the editorial of this issue. So here's his shout out. Thank you, Billy. You are so cute, and it's impossible to be stressed when you are around. To my partner, Jay, and all my friends, I'm so happy that so many of you could be here today. Thank you for supporting me, for listening to my ramblings about unitalicized commas, and for keeping everything in perspective during the busiest of times. Finally, as I've said in my editorial, a very reluctant thank you to any typos that remain in this issue despite our very best efforts to erase them. And I will no doubt catch them years down the track and be very inspired by their tenacity. So thank you for that. That's all I have to say. So I'm very pleased to introduce our keynote speaker, Dr. Ben Gauntlett, who commenced his 5-year term as Disability Discrimination Commissioner at the Australian Human Rights Commission in 2019, and prior to that has worked as a barrister in Western Australia and Victoria with a very broad-ranging practice. He has also worked as an associate at the High Court of Australia and counsel assisting the Solicitor General of the Commonwealth. He's been a solicitor for a large commercial law firm, this one, and taught in Australia and the United Kingdom. Dr. Gauntlett studied at the University of Oxford as a Rhodes Scholar, and as Disability Discrimination Commissioner, he advocates to remove barriers to people with disability participating in society and ensures that the human rights of people with disability are respected. Thank you so much for agreeing to speak to us today. Thank you.
Thank you for that very kind introduction. I too would like to acknowledge the traditional owners of the land upon which I'm presenting to you today, being Gadigal land of the Eora Nation. I pay my respects to any Aboriginal leaders in the audience, past, present and emerging, and I acknowledge any Aboriginal and Torres Strait Islander people who are here today. I would like to thank Herbert Smith Freehills for hosting tonight and acknowledge their tremendous contribution to the UNSW Law Journal, both now and in the past, and hopefully in the future. I'd also like to acknowledge the University of New South Wales Law School for the support that goes into creating an important publication, which is an incredible act of legal scholarship to put together. My last event at the University of New South Wales had a particularly inglorious beginning. I wasn't what Alan Joyce would call travel fit, and I decided to get a taxi to a UNSW event concerning research undertaken for people with an intellectual disability. I was the keynote speaker for an event that was to start at 6:30. At 6:45, as I was in the back of the taxi driving towards the event, and the taxi driver informed me that he really loved the University of Sydney. I realised that I'd have to give the taxi driver some constructive feedback as to where he was driving to. Unfortunately, after providing the taxi driver with some particularly explicit constructive feedback, we decided to reach a negotiated settlement where he would drop me in a maintenance yard at the University of New South Wales. At 7 o'clock in the maintenance yard, an MBA student called Tom from Taiwan at the UNSW kindly picked me up, took me to the law school, and I was met there by a doctor who was a researcher on intellectual disability who took me to the event. What was an introductory address became concluding remarks. It was an important event in terms of specifying the incredible importance that exists in Australia of acknowledging each and every one of us as an individual, particularly when we consider intellectual disability in the community. It is incredibly important that we appreciate the diversity of the human condition. I've been asked tonight to discuss equity in the workplace. Equity recognises that each person has different characteristics and allocates the resources to them to enable them to achieve the opportunities which they want. It is often conflated with the term equality, but at their heart they are both important to discuss in ensuring that each and every Australian and person across the world is treated with dignity and respect. The choice of workplace equity as a topic primarily relates to two articles in the journal. The first being employment discrimination by algorithm. Can anyone be held accountable, by Natalie Sherd, who I note is here tonight, and post-pandemic workplace design and the plight of employees with invisible disabilities. Is Australian labour law and anti-discrimination legislation equipped to address new and emerging workplace inequalities, by Angelo Capuano. The edition, however, traverses a variety of topics. These include a critique of criminal sentencing in assisted suicide and domestic killings, consideration of the orthodox theory of Australian territorial sovereignty, the rationing of justice, tempering the demand for courts in the managerial estate, consideration of the Victorian Human Rights Charter and whether the override provisions should be repealed, the unusual place industry codes of conduct exist in the regulatory framework, social housing, homelessness and human rights, legal duties of research to protect participants in child mainstream services, regulating volunteer directors' duties, companies registered with the Australian Charities and Not-for-Profit Commission, a critique of counter-terrorism legislation in the light of Australia's obligations under the United Nations Convention on the Rights of the Child, and the case of perpetual trustee and Smith being a priority paradox and just how paramount are paramount interests. It is perhaps not what would be described as a cracking read or a rollicking read, but it is an important read in terms of understanding the role of legal scholarship now and in the future. It is a wonderful reflection on you, Akriti, in your skill as an editor, but whilst the topics debates are both diverse and different, the 12 articles fit together in a way that there is a broad range of issues considered, but at all time it is interesting to read each and every article, and for that I congratulate you. And I note your family are here and they should congratulate you as well. Legal scholarship plays an important role in advancing civil society. Especially for marginalised groups, there is a need to ensure that laws and law reform consider the diverse nature of the society in which we live. I had some considerable trepidation when I was approached by Akriti to provide this speech, and that wasn't just relying upon Sydney taxi services. As a student, for my many sins, I was the student editor of the University of Western Australia Law Journal and also the Oxford University Commonwealth Law Journal. In neither Perth nor Oxford was as much weight given to participating in the law journals as exists in the United States, or as perhaps exists now in terms of the workload that is required of student editors. I freely concede I was not a great editor. I used to like to edit while I was listening to sporting highlights, and it was not a way to focus the attention to detail that we should have. And I very much appreciated the comments in your editorial relating to typos. There were many persistent typos which lived on in the publications I edited. However, I did also think that perhaps being a typo was a good metaphor for how a legal career can take place. However, the role and importance of law journals in Australia is often underappreciated and understated. At a personal level, for the students involved, an understanding of how to craft out arguments, write well, and have an eye for detail concerning grammar, referencing, and punctuation is important. Many a judge, partner or barrister has appreciated a junior member of the profession who has been able to clarify expression or fix punctuation or referencing in a way that makes the publication seem as if it was the result of endless hours of reconsideration. And often underappreciated aspect of being involved with a law journal, however, is some of the people who you might meet in considering the articles. I recall, as a young law student, going to spend time in the then Federal Court of Australia Judge Justice French's chambers to discuss an article he was writing. He was, as he still is, humble and generous in explaining his thought processes. We laughed about it some 15 years later when I sat in his chambers when he was the Chief Justice of the High Court of Australia. A young author at the time, who was sending numerous articles to the Law Journal in the field of unjust enrichment and gain-based damages, was a man by the name of James Edelman. James Edelman is now Justice Edelman of the High Court of Australia. At a societal level, participation in law journals can expose young editors, though, to different career ideas and thought processes. It is impossible for law schools to teach every aspect of the law and law and society in a law degree. Tonight, one of the critical issues we are discussing is the use of algorithms. This has been a significant human rights issue in Australia. For example, if any of us considers the use of what is now known as robo-debt, there is and was considerable issues with how algorithms were used in that instance. What would have occurred in a country if we were more alive as to the possibilities or dangers of using technology in a way that was reflective of human rights principles? It is difficult to know, but a reason to respect the importance of scholarship is that raising issues such as the use of technology in a way that is contrary to human rights is of the utmost importance. Many of the articles which are written in this edition of the University of New South Wales Law Journal touch upon critical human rights issues. Those critical human rights issues can inform the future of individuals who we have never met. It is of the utmost importance that as students, but more importantly as human beings, we appreciate the need to respect each and every individual. Tonight, however, I wish to convey to you 3 points. First, every person is an individual who deserves to be treated with dignity and respect. In law and policy, this has both procedural and substantive implications. Second, workplace reform can lead to wider societal reform. And third, the practical effect of law matters. A law that has no effect in society is not a good law. In turning then to the articles which informed the theme for tonight's remarks, in considering post-pandemic workplace design and the plight of employees with invisible disabilities, is Australian labour law and anti-discrimination legislation equipped to address new and emerging workplace inequalities by Angelo Capuano? It seems trite that post-pandemic workplaces in Australia moved to predominantly hybrid working environments after the pandemic. A hybrid working environment combines remote working within an office and allows for workers to work between locations. Technology and associated infrastructure facilitate individuals doing remote work. One of the most common misconceptions concerning disability in Australia is that people with disability are primarily wheelchair users. That is, that people with disability often use some form of mobility aid to go about their everyday living. Approximately 3% of individuals with disability use a wheelchair. The most common forms of disability are invisible in nature. They include, but are not limited to, disability that can be episodic in nature. We know that approximately 4.4 million Australians live with disability. But in discussing disability, the definition of disability is an incredibly important issue for you to be aware of. Before coming here today, I was in a presentation with the APF, which is the Asia Pacific Forum on Disability. The rate of disability alleged to exist in India is approximately 2%. Similar rates exist in other countries in the world. It is not because their population is different in some respects, it is the definition upon which they use to define disability. The definition used in Australia relating to the effect in life domains means that approximately 18% of the population are recognised as having some form of disability. But the Australian Institute of Health and Welfare also recognises that approximately 47.3% of Australians live with some form of underlying health condition. Recent figures released by the Australian Institute of Health and Welfare make for sobering reading in terms of the inclusion of people with disability in the areas of housing, education, employment and health. We have a Royal Commission into Violence, Abuse, Neglect and Exploitation, which is due to report by 29 September 2023. We should consider whether it is a good thing that we needed to have a Royal Commission into Violence, Abuse, Neglect and Exploitation of people with disability to have some of these issues heard. It needs to be appreciated that the recognition of disability and the different types of disability is a fundamental aspect of recognising inclusion in society more generally. It is often discussed what is the model of disability that applies in society. The medical model, the social model, the human rights model. What we do know is the interaction between the individual and the society in which they live, which is of fundamental importance. And we know as a consequence of that that community attitudes and community awareness are a critical issue. In the context of hybrid arrangements, the author in this paper gives careful consideration to the ability to establish an adverse action under the Fair Work Act. The lack of a likelihood of disclosure of an invisible disability means establishing an adverse action is seen to be challenging. A critical aspect of the jurisprudence is an individual had some form of disability which is noticeable. The description of disability used by judges quoted in the article does not reflect a modern conception of how disability is viewed in society or what's reflected in human rights norms. Yet we still continue to use it. The discussion in the article of the operation of the Disability Discrimination Act, but also acknowledging the state and territory equivalents, is illuminating in nature. When the author is suggesting there is a need for law reform in the area, I think the best way it could be described is the author is pushing on a particularly open door. The door doesn't even exist. The terms of operation of direct disability discrimination and indirect discrimination are noted. With it noted that direct discrimination is a result of inequality of treatment based on a person's disability. But this can require the knowledge from the employer of the person's disability, which is very difficult in the case of invisible disability, both from the person having to be aware of the disability itself, but the individual with disability knowing that they need to disclose the disability or disclosing the disability because of reasons of stigma. By contrast, in seeking to make a case for indirect disability discrimination, an apparent neutral requirement, there is an issue with having to show that the disability was a reason for the unfavourable treatment that took place. A concern of the author throughout the paper is that requested. The critique undertaken of the reasonableness test as a defence to unjustifiable hardship defence and the inherent requirements defence carefully links those defences both to the nature of the workplace and the individual in question. It is important to acknowledge that disability is the interrelationship of not only the individual, but the individual and the society or the environment in which they live. It was, however, interesting to read the author's concession that to create defences was going to be extremely challenging, and instead the author made a suggestion that the High Court should not seek to rewrite legislation and that Parliament should do so. Although at all times we respect the separation of powers and how it plays out within the legal system, one of the challenges that often confronts judges is that legislation must be given meaning in particular circumstances that are not always provided for or considered when statutes are drafted. One of the suggestions made by the author is to look to approaches in Victoria and the Commonwealth concerning workplace gender equality laws. Reference was made to the Commonwealth Workplace Gender Equality Agency and the Victorian Public Sector Gender Equality Commission and the policy arrangements that exist in relation to both those statutory bodies. I commend this suggestion by the author, and they may find that this suggestion has previously been made under the letterhead of the Australian Human Rights Commission, not just by myself, but by the late Susan Ryan when she drafted the Willing to Work paper. One of the suggestions she had was to expand the notion of diversity and inclusion in society to include people with disability and older Australians, and to ensure that diverse equality agencies, such as the gender equality agencies, was able to be applicable to them. A reason why it is important to understand the policy framework that exists in terms of inclusion is that the collection of data, the reporting on outcomes, the need to establish framework and policies is an incredibly important aspect of ensuring that people with disability are included in society. Sadly, what you do not measure does not get done. I was delighted, however, that the author of the paper referred to the Australian Human Rights Includability Project guide on establishing an accessible workplace and the importance of universal design. In essence, the article considering invisible disabilities leads us to all to the conclusion that whilst the law must change, the policies creating or surrounding the law must change with it. The article Employment Discrimination by Algorithm, Can Anyone Be Held Accountable? Looks at the use of employers of algorithmic hiring systems to automate or assist with recruitment decisions in Australia and overseas, and notes the dangers of using algorithms in the context of recruitment decisions. It is perhaps prescient that we're discussing this article tonight, not only because the author is in the audience, but last week when I was discussing the dangers of algorithmic hiring, the recruitment manager, Danielle Kelly at Herbert Smith Freehills, was absolutely across the dangers of algorithmic hiring and what could take place. So it was delightful to hear that a person in a diversity and inclusion role had taken the time to inform themselves of what were the dangers of these type of procedures. Perhaps reflecting though an overarching challenge throughout the existing legal system, the insufficiency of Australian discrimination laws in this area is acknowledged, and the references that are made to direct and indirect discrimination law and in the Discrimination Act are noted to need to change. Algorithmic hiring systems have been described by, as in the article, artificial intelligence experts as giving employers a, quote, licence to discriminate. As a statutory office holder that deals with the issues of disability discrimination on a daily basis, this is of grave concern. 3 uses of algorithmic hiring systems in use by employers are considered within the article. Digital job advertisements, curriculum vitae passing, and video interviewing systems. One of the challenges of the use of algorithms throughout the law, but particularly is discrimination, where an aspect of knowledge or intention must be required to be proved to meet the constituent elements of the cause of action, is that an algorithm is not a decision of a person for the purposes of anti-discrimination law. The article itself does not seek to answer the question of the regulation of algorithms, and it would probably be a PhD if it sought to do so, maybe 2 or 3 of them. And I note in respect the Australian Human Rights Commission have produced a paper in relation to human rights and technology. But it is clear that there is more to be done in relation to ensuring that the use of algorithms in hiring systems is tightly regulated, but also better understood by individuals and society. In recruitment, it is noted that algorithmic hiring systems can be used during each of the 4 stages of hiring: sourcing, screening, interviewing, and selection of candidates. At a superficial level, it is noted that the business case for using these tools is strong, provided that a series of assumptions are used as to the accuracy of their decision making. But it is carefully noted by the author that the algorithmic hiring systems can and do discriminate. Digital job advertisements can be targeted to individuals so as to obtain a particular cohort of applicants for a job. Tools used by online providers drawing the detailed profiles have been created by individuals as a source of that data. Unfortunately, what it can do is exclude certain types of job seekers. At the screening stage of the recruitment funnel, the curriculum vitae of individuals is considered. The algorithmic hiring system can look for keywords and other information it believes it is correlated to successful hires, such as the experience, job titles, former employees, universities and qualifications, so as to ensure that allegedly better applicants are considered by decision making in reviewing CVs. 2 causes of bias are noted: bias as a result of the training data and bias as a result of the system design. Bias result of training data is problematic because information is often aggregated from previously obtained datasets to obtain an assessment of what is truth. Bias in relation to this aspect of inclusion in terms of algorithmic processes is problematic because what can result is garbage in, is garbage out. The author refers to the recruitment in Amazon that was affected in this way by an example of biased training data. It is a fair question to ask if there is such a thing as unbiased training data in algorithmic processes that exists in Australia. A human element is always required. Design bias is different to training data bias in that it can occur because of the design structure and rules of operation system it occurs within, the conscious or unconscious bias of individuals. If you input to design and development of a system, of a broader societal and structural element of society, its institutional values are transmitted to the system. Unconscious biases do not survive the algorithmic processes. Unconscious biases can be reflected within the algorithmic processes. It's then noted by the author that video hiring interview systems may be used to pre-screen candidates, and the likelihood of using certain phrases and comments can lead to data points which determine the likelihood of success of a candidate in a particular role. These include the language used by the applicant and audio features of the voice to tell the difference between relevant applicants or applicants who will do well and applicants who may not do well in the profession. It should be noted within this particular aspect of algorithmic processes, how do you decide who is likely to do well off the answers they give to a question and who is not? And finally, the author explores the possibility of different forms of discrimination occurring through CV passing and video systems, and the need for an understanding of discrimination that can occur through proxy that is systemic in nature, and that there needs to be standards to guide the use of algorithmic processes in Australia now and in the future. There are, however, problems of proof. There is, as noted in the paper, a need for law reform. Greater guidelines and assessment of statistical inferences and counterfactuals. The paper concludes by acknowledging the growing body of research in the area, including the Australian Human Rights Commission's Human Rights and Technology paper and some of the other papers that have been produced by, for example, the Department of Prime Minister and Cabinet. How then do we make use of technology to ensure that people of all types are included in the workplace? Technology can be an enormous enabler of inclusion. When I tried to put this speech together, I did so using voice-activated technology. Although the phonetic spelling in some of the aspects of the paper that gets produced can be an element of frustrating, for a person who has no hand function, the use of dictation technology can change lives. Technology is an enormous enabler. But technology can also be deeply exclusionary in nature. Not only from the people that it excludes by use of that technology, but also the processes that it changes in terms of the assessment of whether the decisions made are correct. We know that decisions made by algorithms are not necessarily right. We have to ensure that algorithms are assessed in terms of that they are reviewable, like other decisions that are made in other fields of life for individuals. It is of the utmost importance that scholarship ensures that we understand the importance of technology both as an enabler but also a discriminator. Our legal system needs to change to reflect this challenge. When I talk about the need to treat people as individuals, I talk about it not only in terms of the society in which we live, the legal system and the discrimination and equal opportunity laws that we draft, and the need to ensure that that drafting is appropriate in terms of making sure that people are included, but also that they have access to justice. When I was first appointed Disability Discrimination Commissioner at the Australian Human Rights Commission, I was sent almost within a few days to New York. I thought I was being banished for bad behaviour. I was sent to the United Nations in New York for an event called the Conference of State Parties. And the Conference of State Parties has a particular mechanism to assess or to capacity build in relation to the Convention on the Rights of Persons with Disabilities. I have what could best be described as genetically dishevelled hair, and after getting up early in the morning at my New York hotel, I ventured into the back of a lecture theatre. And a young woman was giving a presentation from Moldova. She was presenting through her support person. And she talked about how ecstatic she was to be moving out of the institution in which she lived into her own residence. And towards the end of the presentation, she said to me, and the best thing that they told me was what my name was. My name is Maria. Maria was 19 years old. Maria had never known her name before she moved out of the institution. That story has always left an indelible mark on me of the importance of considering equity in a whole different raft of circumstances. But one of those is to appreciate that every person we deal with has a name like Maria. When we talk about the importance of workplace reforms, when we talk about the inclusion of different diversity characteristics, acknowledging intersectional characteristics that exist, we need to realise that the workplace can be a microcosm for broader society. That person who serves you food, who has Down syndrome, changes your view as to people with intellectual disability for generations. The fact that a workplace is not homogenous in terms of race, gender, ethnicity, views on religion, or other life circumstances is again enormously important, not only in terms of that actual workplace in which you live, but the broader conception of society and the effect that that can have. We always need to remember that when we discuss workplace laws, is the effect that it can have in other areas of the community. But what jumps out in relation to the articles relating to hybrid work arrangements and algorithmic hiring practices is that we also need to be very, very alive to the important issue of understanding the practical effect of law. A law that cannot be enforced is not a good law. A law that does not give rise to real practical consequences for the people it seeks to protect is not a good law. Through participation in journals such as the University of New South Wales Law Journal and an appreciation of concepts such as human rights, you get to understand the importance of having a legal system which is fit for purpose. One of those is understanding the importance of equity in the workplace. I thank very much the editorial board of the University of New South Wales Law Journal for inviting me to speak tonight. I look forward to reading future editions of your publication, although I may read them in soft copy because they're quite bulky. But I very much hope today that what you take from what I've said from you is the importance of appreciating peoples of individuals, the wider concepts, or the wider effect of equity in the workplace, and finally the need to have practical effects or practical operation of law now and in the future. Thank you.
very much. I also acknowledge the traditional owners of the land on which we meet, and I also acknowledge the invitation from First Nations people to the Australian community to walk with them in the realisation of the promise of the Uluru Statement from the Heart, Voice, Treaty and Truth. My role tonight is a great role. I get to end proceedings by thanking everybody for all the incredible work that they've done and all that they've contributed to the success of tonight and also to the journal. And I begin that particularly by thanking Dr Ben Gauntlett for his address just concluded on equity in the workplace. Thank you so much, Ben. There's so much in what you said. I can't hope to do full justice to everything, but in beginning your address by talking about the diversity of the human condition and reminding us that we must respect the distinctiveness of every individual, I really liked the way you then talked about that and the connection to legal scholarship and its purpose and role in explaining law as it is and the case for legal reform, meaningful legal reform, achieving practical difference in people's lives. You also commented on how that works at a societal level and the breadth in which working on a journal such as this provides to the legal education of students who are running an independent and student-run journal. And those comments really resonated, I think, particularly with us at UNSW, given the founding vision of the faculty expressed in words that I repeat a lot because they're worth repeating from our Foundation Dean, Professor Hal Wooten, that a law school should have and communicate to its students a concern for those on whom the law bears harshly. And the topic of tonight's address, so memorably delivered by Ben, but also the contents of the issue really are a great example of that tradition at UNSW. So thank you very much, Ben, for attending tonight. I'm glad that your attendance was far less troubled than your visit to campus on that earlier occasion, a much smoother experience. And please come out to campus again and come to further journal launches. It was really wonderful to hear from you. I also want to thank Herbert Smith Freehills for their remarkable support over 40 years. Herbert Smith Freehills are a fantastic friend to the Faculty of Law and Justice at UNSW. The Law Library is sponsored by HSF, as well as the China International Business Economic Law Centre. And HSF has a history of many years of supporting projects and initiatives at the faculty. Thank you for playing host tonight to Luke and Antonia, as well as that longer tradition of sponsorship. It was really wonderful, particularly to see Antonia, who I said to her, when were you executive editor? And she said, 2020, which is the year, of course, many of us, it's just a total blur. And Antonia didn't have any live issue launches, so it's wonderful that we've been able to give you that tonight, really. I also want to thank my colleagues, Rosalind Dixon and Gary Edmond, and the role they play in the journal. It's fantastic to hear them acknowledged tonight. I know that they very gladly contribute their expertise and wisdom to the enterprise. But I do really want to conclude by talking about the journal as an independent and student-run journal, which is very important to the faculty. I know it's very important to all of the students who work on the journal, but it is also extremely important to the faculty. We really respect the journal as something that trades under our name, if you like, but is the students' journal. It's not a faculty journal, and sometimes I think people outside of the faculty struggle to understand that idea, but it is, unlike a lot of journals in Australia, it is totally run and the output of all the students' work. There are faculty advisors, but they merely give advice when requested. So I want to talk a little bit about the journal and say how proud the faculty is of it and as the result of our students' work. On Friday, the new Commonwealth Minister for Education and a faculty alum, Jason Clare, visited, and I was really grateful to members of the executive team to join some other students to meet the Minister. And of course, we gave him the two latest issues, and they're great issues to give to a new Commonwealth Minister. The theme of the first one was abuse of power, and the topic that was explained to the Minister Links, this one is equity in the workplace, and he was very appreciative. It was quite a heavy bag by the time he left the building, because we stuffed all sorts of other stuff in there as well, but he was very glad to receive these. And another story, just in recent days, I received an email from someone well known to all the students here, Professor Prue Vines, who's over at the Max Planck Institute in Germany, which is a preeminent European research centre, and she just sent me a photograph of the hard copies of the UNSW Law Journal on the shelves. So, we often don't realise that this work travels very far and sits in some of the great libraries around the world. And I really want to remind the students of that, because your work matters enormously, in many ways that you may not be thinking of. Very far afield. So congratulations to all members of the journal who have worked on the 500 pages of this particular issue. I know that it is a team effort. This would kill any one person to do single-handedly, so thank you to all of you who have contributed. I especially want to thank the executive team under Darius. To lead on any of these issues is a huge task, and the support that the team gives each other is integral to what they're able to achieve. But it is definitely Kriti's night, and so congratulations to you for bringing this particular issue home. I know that it relies on many people who have supported you, not least your family and your dog, to have gotten here. I also noticed your comment around the tenacity of typos. I suspect there's very, very few typographical errors in here, but the theme of tenacity is a good one, because tenaciousness is what gets this done. So congratulations, and well done to everybody concerned in producing this tonight, and thank you again to Ben and to HSF. Good night.
Thank you, Professor Lynch, for that vote of thanks, and thank you, Dr. Gauntlett, for your insightful keynote address. So with Volume 45, Issue 2 of the UNSW Law Journal officially launched, we have now reached the conclusion of tonight's formal proceedings. So please feel free to remain and mingle for the next half an hour or so, and please do not forget to collect a complimentary copy of Issue 45 too, if you haven't already. All of the articles in this issue can now be found on the UNSW Law Journal's website. So thank you all for your attendance, and I hope that you enjoy the rest of your evening.